Do you agree that there was an error in the judgment of the Supreme Court?
If it is in the case of David Lyon, yes, there was error. But in the case of Hope Uzodimma, there is none. I'm happy that the lawyer in your studio stated some of the facts, some of the conditions for review when he talks about the law. Because one of the salient and basic conditions for asking the court, especially Supreme Court, to review its decision and depart from the previous decision is if you can show that the Supreme Court has reached the previous decision per incurium. Now, per incurium has been defined in plethora of authorities of even the Supreme Court, that it is drawn from the Latin word through inadvertence, through ignorance. And inadvertence and ignorance as found in that per incurium must relate to law, statutes, principles of law, which the Supreme Court did not avert its mind to when it was giving the decision, which if the Supreme Court had considered at the time it was delivering the decision, the Supreme Court would not have arrived at the point they arrived at. So that argument that they are giving actually applies to David Lyon's case, because when the Supreme Court was giving the judgment in David Lyon's case, they did not avert their mind to section 140 sub 2 of the Electoral Act, which states that if you nullify an election on the ground that somebody is disqualified, you shall not declare the person who scores the second highest vote as a winner, but you shall order a fresh election. So that is the law, statute, construction, instrument. The Supreme Court did not avert its mind. So David Lyon can come to court and ask for a review. Scoring the highest lawful vote and meeting the required is sacrosanct and a ground on which somebody will be declared as a winner. And Diri in Bayelsa did not meet the second part. And INEC operated as a meddlesome interloper to assume the position of judiciary in interpreting it. That one does not apply in Hope Uzodimma's case. Okay, and in fact, the principle of law is that the judgment of the Supreme Court is final, not because it is infallible, but it is infallible because it is final. But if it is saying that, like in the case of David Lyon, we are not challenging the disqualification. It is proper. It is a law. But having disqualified, there is a provision in the Electoral Act that provides for a relief like that. Section 140 sub 2. That section of the law, it is the key that preserves the sanctity and inviolability of the voters. It is that section that preserves the right of voters. That if you find that somebody has been nullified because he's not qualified, because qualification does not delve on the substance of the vote. Qualification are technical issues. The whole gamut of election is to determine who scores the highest vote. So if you disqualify someone on the ground of qualification, then 140 sub 2 applies. That you cannot declare the person who scored the second highest vote as the winner, like they did in the case of David Lyon. So David Lyon can come to the Supreme Court and ask for review, that the Supreme Court reached that decision in error. Because at the time the Supreme Court gave the decision, Supreme Court did not avert its mind to section 140 sub 2. And therefore, the proper order in the circumstances would have been to declare fresh election. Worst case scenario, let me tell you something, Sean. Please permit me to say this. The Supreme Court is a court of wisdom. It's a court that gives no room for speculation in its judgment. In Yari's case, they not only disqualified the party and the candidate, they proceeded to expressly state that the vote cast for him were wasted votes. In the case of David Lyon, they disqualified him, but they did not make mention of the votes as wasted votes. It gives no room for INEC or whoever to interpret. In any case, if you have a doubt, all you can do is to approach the court again for interpretation, which does not fall within the purview of INEC. Okay. What ought to have been done after the judgment would have been for INEC or the Attorney General of the Federation to advise that the speaker in that House of Assembly be elected pending the resolution of the dispute, because the court did not void the vote. The court is always expressed to say the votes are wasted. In this case, Bwala, the court never said that.
We need to